This week on the Journal editorial report, giving terrorists their day in court, the case against the Detroit bomber and the decision not to hold him as an enemy combatant. Former Attorney General Michael Mukasey is here, and top Democrats head for the exits. 2 Senate retirements shake up the 2010 midterms. Are there more surprises ahead? Welcome to the Journal editorial report. I'm Paul Gigot. The suspect in the attempted bombing of a Northwest Airlines flight on Christmas Day was arraigned this week in federal court. Umar Farouk Abdulmutallab was charged with 6 counts, including attempted murder and trying to use a weapon of mass destruction to kill nearly 300 people. Michael Mukasey was Attorney General of the United States from 2007 to 2009. He joins me now. Judge Mukasey, welcome.
Good to be here, Paul.
You wrote this week that you don't think that Abdulmutallab should have been charged, as he was right after he was arrested, on criminal charges in normal criminal court. Why not?
Well, I think the question really, for me, the principal question is timing, not so much where he ultimately wound up, which I think is secondary. But he should have been taken initially, designated an unlawful enemy combatant, or in the current parlance, an unprivileged
belligerent.
Belligerent, I think is what
yeah, that's what they called him. Yeah,
right.
Sounds like your average New Yorker. Actually.
Right, exactly. And questioned by people who were interested in intent on intelligence gathering because he had a lot of it. He knew who had put him on that plane. He knew who had mixed up the stuff that he had in his underpants. He knew who had trained him, who had radicalized him, and so forth. He had a wealth of information. We're never going to hear about that, and we're certainly not going to hear about it in a timely way. And the failure to do that, I think, was a major, major gaffe.
The argument, though, you hear from the administration is that if he was named an enemy combatant, he would have the right, under the Supreme Court ruling, to have a habeas hearing. And then if he won that habeas hearing, he could be released.
The habeas hearing could challenge only the propriety of his confinement. His confinement could be based on the fact that he was dangerous. And given the fact that he was apprehended with a bomb in his shorts, I think the hearing on a habeas petition would be short and sweet.
So your argument is that the priority here for any administration needs to be, when you're arresting suspects like this, needs to be on collection of intelligence to protect against the next terrorist attack and not on some kind of adjudication, a conviction, making sure he stays in prison.
Correct. Once you've got him in custody, you virtually solved that problem.
He's going to be, in one way or another, in detention for many, many years.
Right. You need to be forward-looking and forward-leaning. And when the President yesterday failed to mention that failure among the failures that he listed in investigating this case, the omission was glaring.
Well, what about the argument that, look, we've tried Richard Reed, the shoe bomber, we've tried in criminal court, we've tried Zacarias Moussaoui, the alleged 20th hijacker, in criminal court. They went away. Those worked fairly well. Why not Abdulmutallab?
2 points. First of all, Richard Reed, you remember, was apprehended barely 3 months after 9/11. We didn't have any of the procedures in place, although we had an order authorizing military commissions. We had none of the elaborate procedures in place for actually implementing military commissions.
Now those are established.
Proverbial, we didn't have our act together. And so he was put in a civilian court. Ultimately, it worked. As far as Moussaoui is concerned, my judgment on that is it did not work. He pleaded guilty. He didn't contest his guilt, and his sentencing proceeding took over a year. The appeals took 4 years. I don't consider that working.
That's not a success.
That's not a success story.
The other argument is, and you've heard this from John Brennan, who is the senior White House counterterrorism official this week, that you can charge these people, that you can do a plea agreement, basically, with somebody like Abdulmutallab. You know, we'll talk with his lawyer, say in return for perhaps a lower sentence, now you'll cooperate. We do that all the time with criminal defendants. It can work in this case.
Yeah, 2 problems with that. Number one, at the stage at which we do that, most of what he knows is already dated and useless.
So the crucial thing is getting actionable intelligence right away that you can then use to prevent something if it's planned.
But secondly, what kind of message does it send? We're bargaining with terrorists over reducing their sentences? I think that's ghastly.
But they say, look, we're sending a message to the world that we treat everybody equally under the law. That sends the right message to the world because they'll like us better because we show we don't have these secret prisons and so on and so forth. That seems to be the real root of a lot of the case for trying him just like a criminal.
We sent that message several times. We sent it before the Cole bombing. We sent it before Khobar Towers. We sent it before 9/11, and we see the results. It's not a question of convincing the rest of the world that we have a fair system. We have a fair system, and there's no reason why that fair system can't eventually be applied even to these people, if people choose to do it. But the first priority is making sure that we gather intelligence so that we can stop the others.
All right, now the president did say this week that he's no longer going to be sending detainees back to Yemen, where obviously they have an active al-Qaeda cell. You agree with that decision?
Insofar as it goes?
Yes.
Sure.
But he's going to send them to Thompson, Illinois, instead. You agree with that one?
No. And my prediction is they're not going to agree with it either once they see the difference between Guantanamo and Thompson, Illinois. I've been to Guantanamo. It compares favorably with most medium security, forget maximum security, medium security federal prisons. It is remote, secure, and humane. And when they get over there and find out that they're in a freezing facility of cinder block and don't get to play soccer in the sun, you're going to hear a lot of complaints about prison conditions. You're going to see a lot of lawsuits relating to prison conditions. You're going to see a torrent of lawsuits addressed to that, habeas petitions, and so forth. It's going to be a lawyer's feeding frenzy.
Is it at all possible, when the courts hear those habeas petitions, that some of those detainees could end up being released in the United States?
Yes.
At Thompson?
Yes.
How would that work?
Well, someone would bring a habeas proceeding. Some federal judge would decide whether the evidence that's presented to him, and again, some of this may be classified evidence that either can't be presented or can be presented only in redacted form, isn't sufficient to justify holding him. And then he's going to have to be released. The question becomes then where he's released. Ideally, he should be deported. But if no country is willing to take him, there's a Supreme Court case called Zadvydas versus Davis that basically puts a 6-month limit on how long we can hold him. Now, even the Supreme Court said in that case, we're not talking about terrorism cases, but these things have a way of ratcheting up and becoming incremental. And so I don't know whether that little exception in Zadvydas, if in fact it's seen as an exception, would hold eventually.
And as long as Guantanamo is still open, if you had that kind of a hearing, they could at least be held there indefinitely while you were looking for a place outside the United States where they could be held. Now,
and I stress it's held under humane conditions. It is a very well run, professionally run facility. All the skills that were acquired in running it are going to have to be reacquired when they open this new facility in Illinois, if they do.
Now, you presided over terrorist trials in New York in the 1990s, the Blind Sheikh. What lessons did you draw from that you think will apply to the coming Khalid Sheikh Mohammed trial here in the city, the mastermind of 9/11?
It has to be done with great care. The anonymity of jurors and their safety, and of witnesses and their safety has to be preserved. The security of the courthouse has to be preserved. Even if you do that, jurors don't parachute out of thin air. They've all got friends and associates and colleagues who can figure out that they're on that jury, and eventually the word is going to get out. I had an anonymous...
So you're saying they're at risk?
They're at risk. I had an anonymous jury in my case. Their identities were not disclosed. The day of the verdict, 2 of them found reporters on their doorsteps when they went home. They were terrified.
You think it's a mistake in general to have brought, overall, to be bringing this case here in
It's a huge mistake, not only for reasons of security surrounding the trial, but because it puts a great big target on a city that's already a great big target, and that is New York. New York is the biggest stage in the world. It gives that stage to the terrorists on trial, and it also gives that stage to their friends who may want to make a dramatic statement in the form of a terrorist act.
Why do you think the administration is doing this? Because they must understand these risks.
I don't read minds. I can't hypothesize about a good reason why they would do it.
Well, I mean, it's likely that some testimony of his waterboarding is likely to come out. He can use that as a propaganda tool, can he not?
Of course he can. And if that's the reason why they did it, in order to re-condemn that technique, it seems to me that that is certainly inadequate. In fact, it's a shameful basis on which to hold a trial.